Okay, good morning, class. Today I'm going to be recording your tests only. So it's 100 jury charges. Make sure you access the speed building. And jury charge number 1, you have the courts, capitalized courts, apostrophe S. And remember, you can write DORT, D-O-U-R-T, and then apostrophe S, okay? And that's it. This is test 100, jury charge number 1 for 5 minutes, you all. Members of the jury. There are some preliminary instructions that I have to give you at this time, and I will proceed to deliver those to you. Thereafter, we will recess for the day. I indicated the procedure in the case, and actually we'll proceed with this procedure tomorrow. The procedure is quite simply the opening statements, and I indicated to you earlier that these opening statements are not evidence and they are not arguments. They are simply made to give you some idea of what the case is all about. The prosecuting attorney may make an opening statement to you concerning the evidence that he intends to produce in support of the charge. He is under no obligation to do so. Likewise, the defense may make a statement concerning the evidence to be produced, or she may reserve the right to do so until the completion of all of the evidence is offered by the prosecuting attorney. Now, after the opening statements, the prosecution must offer evidence in support of the charges in this information. The defense may offer evidence on behalf of the defendant, but is not obligated to do so, as I previously indicated. The burden is always on the prosecution to prove each and every element of the offense charged beyond a reasonable doubt. The law never imposes on any defendant in a criminal case the burden of calling any witnesses or introducing any evidence. The prosecuting attorney may, if he choose, offer evidence in rebuttal of any evidence that is offered during the defense's case. Now, at the conclusion of the evidence, you will be instructed in writing as to the law that is applicable to the case. They will be read to you, and you will be allowed to take the instructions with you to the jury room. The prosecuting attorney may then deliver a summation of the case and base an argument for conviction on the evidence and the law as given in the court's instructions. The defense may then deliver a summation of the evidence to you and base an argument for an acquittal or other verdict on the evidence and the law as given in the instructions. Then the prosecuting attorney, who has the burden of proof in this case, may choose to reply to the argument made by the defense. The reason why the prosecuting attorney has the last word is because the burden of proof is always resting upon the district attorney. Finally, you, the jury, will then retire to deliberate upon the verdict. Your purpose as jurors is to find and to determine the facts. Under our system of criminal justice, You are the sole judges of these facts. It is especially important that you perform your duty of determining what these facts are or are not diligently and conscientiously. It is up to you to determine the facts from all the testimony that is produced during the trial of this case. It is up to you to determine and then we have your second test, verboten. Verboten, let me write it for you. Verboten. Okay? Verboten. This is going to be then jury charge test number 2-120 for 5 minutes. The law which will be read to you constitutes the only law for your guidance, and it is your duty to accept it and follow it, even though you may have some personal disagreement with it when you hear it. It is your duty to apply the rules of law as given in the instructions to the facts as you find them to be, and in this way arrive at your verdict. Now, I must also give you certain admonitions or warnings that will remain with you throughout this entire trial. They will remain with you whether you are at home or at recess, or we just have taken a temporary adjournment. The first one is this: you are not to discuss this case among yourselves while the evidence is being presented to you. The first time that you will be allowed to discuss this case among yourselves is after you have heard all of the evidence, the instructions of the law, the arguments of counsel, and have retired to the jury room and have selected your foreman. Then and only then should you begin to discuss and to deliberate upon this case. Obviously, you are at liberty to visit among yourselves during recess and adjournments. The only subject that is verboten is this particular case. Now, the reason for this rule is that you might commit yourselves one way or the other before you have had an opportunity to hear all the evidence, the instructions, and the arguments of counsel. So therefore, you are not to discuss this case among yourselves until all these other events have transpired. The second warning is that you are not to discuss this case with anyone else. That is, any third person, until your verdict is delivered and you have been relieved of your duties as a juror in this case. The reason for this rule is that very often these third persons, be they husband, wife, friend, or relative, may have their own ideas to how this case should be decided. Discussion of their ideas with you would be totally wrong and improper and may have some influence upon you. So, to prevent this possibility and to prevent the temptation, you simply shouldn't discuss the case or any aspect of the case with any third person. Thirdly, should any other juror or anyone else attempt to discuss this case with you, you should notify me at once. Fourth, you are not to read or to listen to any accounts or discussions of this case that may be reported by newspapers or other publications or by radio or television. I have no reason to believe that any such publications will appear, but obviously if they either appear or are broadcast, you should avoid them. The reason for this is essentially the same as the reason for not discussing the case with any third person. You are going to know precisely what the facts are based upon the evidence and what may be reported. And then we'll go to your second 80s, your 80s, okay? Okay, so you have on your 80 test number 1, proper names. You have none, okay? None. This is going to be test number 1 for 5 minutes jury charge. But what a defendant does or fails to do may indicate intent or lack of intent to commit the offense charged. You may consider any statement made and done or omitted by the defendant and all other facts and circumstances in evidence which indicate his or her state of mind, unless otherwise instructed in determining the issue as to intent. The jury is entitled to consider any statements made and acts done or omitted by the accused, and all facts and circumstances in evidence in the case which may aid determination of state of mind. As stated before, the law never imposes upon a defendant in a criminal case the burden or duty of calling any witnesses or producing any evidence. A separate crime or offense is charged against the defendant in each count of the indictment. Each offense and the evidence pertaining to it should be considered separately. The fact that you may find the accused guilty or not guilty of any offense charged should not control your verdict as to any other offense. The defendant is not on trial for any acts or conduct not alleged in the indictment. If you find and believe that the essential elements of the particular offenses charged in the indictment have been proved beyond a reasonable doubt, it is your duty to convict the defendant whose guilt or innocence you have under consideration, and you may do so. If you do not so find, or if you have a reasonable doubt thereof, then it is your duty to acquit such defendant, and you must do so. You are entitled to use your common sense. You are entitled to draw deductions from the evidence by the use of your common sense and to try to arrive at the facts of the situation in the light of the court's instructions as a whole, and particularly the one as to the burden of proof. The trial of a case is not a game. The outcome of this case is important to the public, and it is important to the defendant. Both sides are entitled to have you make your best effort to decide what the facts are in this situation in light of the evidence that you have heard by the use of your common sense. You must arrive at the facts from the evidence that you have heard here and draw whatever deductions you. And then we've got your second AD jury charge. Proper names, Arthur Penn and vehicle code. So vehicle code is VOD, V long O-D for vehicle code, okay? This is going to be then AD number 2 test. Jury charge for 5 minutes, you all. As I have before instructed you, the burden is upon the plaintiff to prove by a preponderance of the evidence that the defendant was negligent. She must also prove that such negligence was a proximate cause of the injuries alleged to have been sustained by plaintiff. The proximate cause of an injury is that cause which, in natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury, and without which the result would not have occurred. It is the efficient cause, the one that necessarily sets in operation the factors that accomplish or bring about the injury. While operating his automobile at the time and place in question, the defendant, Arthur Penn, was bound by law to operate his automobile in a reasonably careful and prudent manner, and was required to exercise ordinary care in the use of his senses of sight and hearing, and also to keep a reasonable lookout for other persons lawfully using the street involved. He was also required to use ordinary care to keep his vehicle under such control that to avoid a collision, he could stop as quickly as might be required of him by events that could be anticipated by an ordinarily prudent driver in a similar position and in like circumstances. Negligence is not based upon the possibility of avoiding an accident. The defendant may not be held liable for negligence merely because he might have avoided the accident had he acted differently. If the defendant did all that an ordinarily prudent person would have done under the same or similar circumstances to avoid the accident in question, the defendant is not chargeable with negligence and may not be held liable in this case. There is what is termed under our vehicle code a basic speed law. And that section of the code provides as follows. No person shall drive a vehicle upon a highway at speed greater than is reasonable or prudent, having due regard for the traffic on and the surface and width of the highway, and in no event at a speed which endangers the safety of persons or property. That section of the vehicle code must be considered in the light of the principle of law that applies in the case of violations of a statute or code which have been proved. That principle may be stated as follows. The violation of a provision of okay, you all. So that concludes your test. Have a great day. Hopefully you got one, okay?